What's going on? We are back live. We have a lot to go over today. We get off into Joe Rogan interview, interview your boy Antonio Brown. And you have to watch what Antonio Brown shows up to the interview in. But again, hey, Antonio Brown looks like he has scored a victory with the United States Patent and Trademark Office. So we will get into that. We also have a lot to talk about. Shark Tank, after a while, has finally aired a new episode. So I'll let you know what I think out of those four pitches is probably going to be the winner kind of going forward. We have a lawsuit to get off into. What is it called? Glow recipe, watermelon glow recipe. So we'll talk a little bit about that, as well as let's see here. It seems like Trader Joe's has been in the news. So we'll talk about Trader Joe's and those unionizing efforts and whether or not the business entity Trader Joe's is looking to try to thwart those unionized efforts by some maybe illegal activities. We'll talk about all that. But again, how are you guys doing today? I am Dave. If you don't know, 10-year intellectual property attorney dealing with everything. As you can see, the shirts, patent, copyright, trademarks, as well as trade secrets. And yeah, we have a little bit of everything going on today in the stories that we're going to kind of talk about today. Please leave. First of all, housekeeping items. Please hit the like button for the YouTube algorithm, as well as hit the subscribe button to be a part of the IP community. I would personally love to have you guys as part of the IP community. We have a little bit of everything, which I guess this show is going to tell that we kind of get off into on a weekly basis. And hopefully you guys turned the clocks. I'm not sure if it was back or forward. And now we're at least here in the great state of Michigan. It is daylight saving times, or I'm not sure if it ended or began, one or the other. But I can tell you what, typically at 7 o'clock, it's starting to get dark here, but it's still has a nice sunshine outside, so I'm excited about that. It's even warming up. March, it really doesn't kind of get in the clear until about May here in Michigan. So March, still got March and April for it to kind of the weather to swing a little bit before it starts to really kind of sunshine more consistent in May. So yeah, that's all that we have. So let's get started here. We're going to talk first and foremost about your boy Joe Rogan and Antonio Brown, CTESPN. Let's kind of pull it up here. Look it. There you go. There's your boy go. Antonio Brown showed up to Joe Rogan in the World War II helmet, the World War II attire. He still got the drip on, as you can tell with the necklace. But let's kind of pull up that interview really quickly and see what he has to tell Joe Rogan as relates to CTESPN. So let's go, and then I'm kind of going to give you my thoughts on this one. Let me make sure it's on. Sometimes I look at these things on too. So here we go.
How did you come up with hashtag CTESPN? Because that's my favorite.
I feel like when I stopped playing football and I walked off the field, people was like, this guy's crazy. Like, he's retarded. You know what I'm saying? He's illiterate. So, I was like, you know what? Maybe I could, rebrand CTESPN with, giving people perspective of different challenges people face and great individuals, how they overcome adversity, and just kind of share and tune perspective of, how people is getting through trauma. No matter if you're a football player, I mean, what it's like for you. You started UFC, like
the reality of head trauma.
So again, Joe Rogan gets to talking about the reality of head trauma. But for those of you who don't know, Antonio Brown, he actually have a company called CTESPN, which is a marriage of CTE, which is the brain trauma, the brain injury that so much, particularly football players in the NFL kind of go through, and unfortunately a lot have kind of succumbed to. And obviously the sports broadcasting network ESPN. Now, I talked about months ago, sometime last year, earlier in the year, how ESPN sent Antonio Brown a cease and desist letter for CTESPN. And again, you have to give Antonio Brown credit because he actually filed for trademark protection on the term CTESPN. Like I said, that's a marriage of CTE, which is the brain injury, where a lot of people are saying, hey, based on, I think, Burfict, one of the Cincinnati Bengals players, linebackers, when Antonio Brown was playing with the Pittsburgh Steelers, kind of hit him, kind of was killing him, not killing him literally, but laid some pretty hard hits on him during that game, and it seemed like Antonio Brown hasn't been the same. So a lot of people say that, hey, Antonio Brown, he has CTE. And again, that's why he acts differently. Again, I'm not here to kind of judge whether or not he does have CTE or not, but it seems like Antonio Brown has made the most out of it. Obviously, I'm not sure if he's trolling or not. Showed up to Joe Rogan with the World War II attire on, particularly the helmet. But again, Antonio Brown has created a company that covers sports, and it's called CTESPN. Like I said, a marriage of CTE as well as ESPN. And like I said, you have to give him credit because he filed for a trademark with the United States Patent and Trademark Office, which a lot of people should do. If you have a business that you're starting with as a podcast, whether it's a broadcasting company, whether it's you're selling widgets, you're selling apparel, whatever the case may be, you need to be able to protect your intellectual property, whether that's trademarks, whether that's patents, whether that's copyrights or trade secrets. And Antonio Brown did that. He actually filed for trademark protection on CTESPN. Now, I thought that ESPN, especially since they looks like sent them a cease and desist letter early on, was going to have some issues with it. But it seems like the United States Patent and Trademark Office has allowed the mark, which means that he can actually register the term CTESPN for his kind of news coverage or sports coverage. Now, he has kind of jumped through some formality issues kind of based on him filing the name in the trust. Go check out that video that I've done on that. He has to kind of, correct those, but it seems like for all intents and purposes, is going to be able to protect the name CTESPN, which is amazing because I didn't think that was something that he was going to be able to do when this thing initially started out. So kudos for Antonio Brown, him being on Joe Rogan, especially with the attire on, the World War II attire on. We're going to move on to the next one, which is, let me see here if I can bring it up. If I can bring it up. Here we go. The USPTO, United States Patent and Trademark Office, has, or maybe is in a process potentially of canceling 42,000 trademarks from China. Now, again, call it what you want. Obviously, we have a new administration change in the White House, and our relationship with China has not been good for a long time, particularly as it relates to intellectual property, as a lot of copycats, a lot of knockoffs come from China. And I'm not sure if this is Trump's way of kind of saying, hey, let's put an end to it, or this was just a long time coming. I did a video, so go check out that. That kind of really kind of went through the details. I'm not going to go through it in detail here, as kind of these kind of short stories outside of the lawsuit are more so weekly recaps where I'm kind of quickly hitting the story. But again, United States Patent and Trademark Office has issued a show cause order to cancel more than 40,000 China-originated trademark registrations. Now, Shenzhen is actually the company, and I'll kind of break it down for you guys a little bit. When you're filing trademarks or any intellectual property for that matter, whether it's patents, you're overseas, you can't file that directly with the United States Patent and Trademark Office. You have to get a counsel that's here in the U.S. in this case to facilitate that filing of the intellectual property. Like I said, whether it's patents, whether it's trademarks, whether it's copyrights, so forth and so on. Now, me as a practitioner, if I'm filing a patent, for example, which I've done this a lot of times in Europe, in China, in India, I have to communicate with foreign counsel, give them instructions to actually kind of file it with their patent office, with their respective patent office in that jurisdiction. I can't file it with China, for example, or with different countries in Europe. I have to kind of work with foreign counsel to do that. So this is not anything new for China to have to kind of work with foreign counsel or with U.S. counsel to file these trademarks. It seems like, according to the article, and again, I went through the article in detail and broke it down and gave you guys my thoughts. Seems like in this case, China, as opposed to working with counsel, or at least what's being alleged from the United States Patent and Trademark Office, seems like China, as opposed to working with U.S. counsel to file the trademarks here in the U.S., they actually filed the trademarks themselves, or the company Shenzhen, I should say, which is a firm located in China. Seems like they filed the trademarks on their own. And again, for anyone who has filed trademarks here in the U.S., you have to the extent, if you're a U.S. citizen, you can kind of file a trademark on your own. But if you're a company, if you're being represented by somebody, an attorney, you have to kind of enter in their information. So I have to enter in my P number, what state that I'm licensed in, the practice law, which obviously, again, is the great state of Michigan here for me. You have to enter in all that information. And it seems like China, they don't enter in the information, as opposed to entering in a U.S. a lawyer when they're filing these Chinese-based trademarks here in the U.S. They fraudulently, or at least, again, this is being alleged by the United States Patent and Trademark Office, China, or the company Shenzhen, which is a firm based out of China, you got to listen to me. They actually was fraudulently entering in U.S. based attorneys, the P number, their name, without that particular attorney in the U.S. authorizing it. So they're essentially were filing trademarks of kind of not making up names, but entering in U.S. attorneys without actually having their permission or their authorization. It seems like this has been going on for a long time with China over Shenzhen in the United States Patent and Trademark Office. Seems like back in 2022, the USPTO slapped Shenzhen on the name, Shenzhen on the hand for doing this. They did it again, I think, at the end of 2023. And 2025, I guess the United States Patent and Trademark Office said, hey, I had enough. You have to come in and show me why we shouldn't cancel 42,000 trademarks. So you're talking about a blow. That can definitely be a blow to Shenzhen, the firm, and kind of how they do business from kind of Chinese resident Chinese businesses who are looking to file for trademark protection here in the USPTO. If you have 42,000 trademarks, that gets essentially goes abandoned based on their fraudulent or their alleged fraudulent activity by the United States Patent and Trademark Office. So definitely go check out that video that I did earlier this week. I dropped maybe a couple days ago. So in the meantime, we are going to continue moving on and talk about the interview that came out this week. And we're actually going to play something. We're going to play a snippet of that interview, and then I'll come back and kind of give you my thoughts on things. So this is Sarah Sledabo, who she came up with Dry and Stride, which is essentially a towel that she has got a patent on. Let's go to it. Let's kind of go through her story. Let me have her tell it, and then we'll come back and I'll kind of give you my thoughts. Let's go.
Pretty creative. So, I mean, I even remember as a kid coming up with an idea to do XYZ. And Dry and Stride actually took about 8 years from when I thought of the idea to actually getting brave enough to get a product to market. And there was a lot of reasons for that. One, you've got to research. Two, find vendors. Again, all these things that you don't even know you need to do. We did apply for a patent because this is a little bit unique, and I wanted to make sure we had some of that groundwork done before we launched. But really, I mean, there's financing, there's funding, there's volumes. As much as I would love to say I have 500,000 towels ready to go, I am not at that level yet. So thankfully, this journey has been as big or as small as I've been able to take it at each given time. It wasn't, I never had to do it. I chose to do it. And I think that's really helped my comfort level, my passion, and my engagement, because I want to do it. I don't have to do it. So I think there's just kind of a little bit of a break there.
So that's Sarah Sledabo. Again, like I said, I interview every week. I come out with a interview of somebody who has created a product, created a service, a business, or created a business based off their product or service, and are bringing it to the market. She's one of the few people. A lot of these people businesses are Shark Tank companies, but she's one of the few companies that aren't Shark Tank. You see to the left hand, her product Dry and Stride, which is a retractable towel. You see the towel on everyone's hip in the corner on the left hand side. And again, this towel is similar to like an ID badge that you have, kind of pull out and kind of badge into a building, badge into an office. It's a similar thing, but if you're working out, if you're cooking, if you're doing any activity where you need to kind of, you have sweat or you need a towel for, this Dry and Stride towel facilitates that or helps out with that. Again, she talked about having a patent on it. Specifically, she has a design patent. So for those of you who don't know, you can file for 2 different patent applications. Actually, you can file for 3, but typically you'll file for utility patent, which protect the function of an actual product. And you can file for a design patent, which protects the actual ornamental features of a product. And in this case, she kind of talked about, please go check out the interview in detail. I think it was 42 minutes, a little bit over 42 minutes. She talked about how she thought she wasn't going to be able to get a utility patent, so she protected the actual product by way of a design patent. So that's her product that she invented. She's looking to launch, I think, here soon. And again, she talked in the interview where, that's one of the good things. I know I wouldn't probably say wait 8 years as she did before coming up with the product, but one of the cool things that she talked about I do want to hit on is, hey, when you're selling these things DTC and you're not necessarily kind of in stores, one of the benefits of that is being able to go at your own pace. You got your website, you're on these kind of e-commerce platforms, whether it's Shopify, whether it's Amazon. You kind of sell these things at your own pace as opposed to having a warehouse of 500,000, a million units of a product. You can maybe order 10,000 or even, heck, 1,000 sell those, maybe order another 1,000 and kind of go like that. So again, I think that's beneficial for people who want to kind of go at their own pace as opposed to feeling like they have to go from 0 to 100 really quickly. And yeah, I mean, it's a pretty cool product. Go check out the interview in the description section on, whether you're doing a podcast or on YouTube. It's a 10% discount if you type in the code. I forget the code offhand, but it's actually in the description of that video. So again, if you want one of these towels, definitely go check out the interview regardless. But if you want one of these dry and stride retractable towels for yourself, whether you're working out, whether you're a cook, whatever the case may be, that you're kind of performing an activity that maybe you need a towel for, to kind of sweat towel or something to kind of wipe around the area that you're operating in, go check out that interview. Use the promo code to get 10% off of that retractable towel for dry and stride. And again, shout out to Sarah Sledabo for her product, for her business, and kind of for the interview that came out this week. Let's continue to move on here. Kid Coffee. Now, like I said before, Shark Tank, make sure I kind of pull this up. Shark Tank hasn't been out for, they haven't released a new episode in a couple weeks here, but they just recently released a new episode. Let me see if I can, and so they do 4 pitches. And I typically like to try to kind of pick out what 4 pitches of those Shark Tank episodes that I think is going to kind of do numbers. And this was a cool one. And the interesting thing about this product, Kid Coffee, is, again, go check out the Shark Tank. Actually, I posted the video of me kind of breaking down the Shark Tank pitch, Kid Coffee. A kid actually came up with this product, Kid Coffee, hence the name Kid Coffee. Apparently, Pops was giving the guy a coffee. And again, the kid, I think he's only like 7 or 8 years old, this is why I love entrepreneurship, because it isn't like, okay, you have to be 18 years old or 30 years old, a particular age to do it. This kid, literally, again, he came out with this product, Kid Coffee, and he's only 8 years old. And he actually got a deal on Shark Tank. So kudos to him and his pops. And again, shout out to his pops, because his pops seemed like he kind of is the man and kind of guided the kid along the journey from kind of producing a product and kind of getting it out there. These guys are killing it. They actually just launched in like April of last year. And at the time that they did the Shark Tank pitch, they had already made $75,000 in annual revenue. So the company is making money. And I think as this thing gets more and more out there, this product is going to be cool. Just because, obviously we got coffee is a thing, but you don't have coffee for kids, so to speak. And hey, if anybody's like me, man, growing up, you're going to have a aunt or a whoever that's going to slide you some coffee for you to drink, or you're going to have a uncle that's going to slide you some beer. So hopefully you don't get the beer product, but Kid Coffee, go check it out. Again, Shark Tank pitch. I think this is one of the 4 pitches that is going to do numbers going forward. Like I said, the kid who did this, the person who founded this company, Kid Coffee, he's only 7 years old. So this doesn't give any excuse that you and I have, whether we're 20, 30, 40 years old. You have no excuse for coming up with a product and starting your own company. As Kid Coffee, what came out is founded by a kid that's only 7 years old. I think he's not even in middle school, or maybe he's in like 5th or 6th grade now. So again, Kid Coffee, go check it out. It's for kids. Clearly, it's not coffee, but it gives you the nutritional value, as well as other things that kids may need, calcium, things of that sort. And apparently, it's good according to the sharks on Shark Tank. So go check out that video. Go check out the product. Kid Coffee is a thing. And let's continue to move on here. The Ultimate Human. So for those of you, I am a big Patrick Bet-David fan. And it seems like he had this gentleman on. We're going to play this video. I want to show you how not to get played as an entrepreneur. So let's go through this video really quickly. Then I'll come back and give you my thoughts. Let's go.
Perfectly. And, they put 250,000.
So just give you the lay of the land. So this gentleman, Gary, he came out with a product. He has a podcast called The Ultimate Human, which you can see a little bit on the shirt. He, again, they sell genetic testing as well as different nutritional supplements, things of that sort. And he entered into a deal. I don't want to say entered into a deal. Grant Cardone, which I like Grant Cardone. He bought the company for $250,000, or bought 82% of the company for $250,000. And this guy, Gary, and his wife, they retained 18% of the company. So if you figure you bought a company for $250,000, to me, as a businessman, that means that the company was doing anywhere from $10,000 to $20,000 a month. So in other words, it was doing anywhere from maybe say $120,000 to $300,000 a year. And Grant Cardone bought the company, bought 82% of the company, gave him and his wife $250,000. And now the company is doing $17 million. So you got to check this out. If you're doing $10,000 to $20,000 a month in revenue, and all of a sudden you sell your company, and the guy who bought your company is doing $17 million in revenue a month, the guy just essentially added fuel to the fire of your company. But it seems like in this case, this guy, again, he really wants to help people from my understanding, and seems like a good guy from me kind of watching this clip beforehand, but he doesn't have the requisite business experience, and it seems like he's kind of pouring out his frustration. So that's where this video starts up. I would love to hear you guys' thoughts in a chat, but let's see how he screwed up big time, particularly from an intellectual property standpoint. Let's go.
$1 in our pocket to buy this company, which I immediately put into Cardone Capital. So we never took any money off the table. When the company started making money, they stripped $9 million out in distributions to themselves, hundreds and hundreds and hundreds and hundreds of thousands of dollars in totally unnecessary fees, because Cardone Ventures, which owned 82% of our company, has this thing called the Strategic Business Unit, which is a bunch of untrained young entrepreneurs with no specific expertise in the area of business that they sell services in. And even though they owned 82% of our company, they still charged massive fees every month, which they paid to themselves to scale our business. Our business wasn't scaling because of the Strategic Business Unit. Our business was scaling because the message was resonating.
He's talking about the business wasn't scaling because of the strategic plan. And dude, they took your company from $20,000, $10,000 to $20,000 a month to all of a sudden doing $17 million. You think it's because of the messaging that you guys were doing? Okay, let's continue. Let's finish up this.
You don't think he
PPD pulls it out.
17 million that 1 month is of that business that they owned 82% of? That business at 17 million in a month. Wow, that's pretty explosive. So you don't think the 10x?
Oh, your boy PPD is even saying like, dude, they did 17 million. You don't think that's explosive for your company who was doing maybe $10,000 to $20,000 a month? All of a sudden is doing 17 million. Okay.
And Cardone promoting and talking about it helped get it off the ground.
It helped me a lot. I mean, I never, first of all, I owe a debt of gratitude to Grant Cardone for even taking the risk of saying that he wanted to partner with our company. I don't take that away from him at all. In fact, a lot of my issues are not with Grant. I mean, I think Brandon Dawson, his partner, is going to be the downfall of the entire organization. I think,
so you and Grant are good. You don't have issues with Grant.
I don't have real issues with Grant. I mean, he's got a few issues with me because I left. I mean, basically they said either sell this test or we terminate you. And I said, I'm not selling the test. I am not going to use my reputation to shove this thing down the throats of patients that I care about. Some of the clinicians that have been in my business since we started that business, some of the employees that are there, some of the practicing clinicians are some of the best people in the entire world. You want to hear something amazing? So they
what is that, Rob?
They're now launching the so on January 4th, I have the Ultimate Human. It's my podcast. Mm-hmm. They went out on January 4th and bought ultimatehuman.com. I have the Ultimate Human. They bought ultimatehuman.com, and now they're launching Ultimate Human Analysis. The 10X brand has been so damaged and so destroyed.
We're going to finish up this clip here in a little bit, but just to kind of give you guys what he's saying that Grant Cardone and a team, this guy has the Ultimate Human podcast, which he doesn't have a domain name for. Heck, he didn't even file for a trademark. Now he get in bed with some big dogs, Grant Cardone and a team who are, hey, when you're talking about business, man, you're in the big leagues. He's laughing, not knowing that, hey, man, the joke is on you because Grant Cardone and the team bought the Ultimate Human Analysis trademark, bought some domain names, which, dude, you should have been bought. If you would have bought those domain names and a trademark, got those trademarks registered, you would have sold your company for a lot more than $250,000. I can guarantee you that. The IP is an asset to the company. Essentially, it seems like you're saying that you sold the company for 82% of the company for $250,000 to Grant Cardone. I guarantee you, if you would have had trademarks for the Ultimate Human, if you would have had domain names, all that intellectual property, you would have sold that company for a lot more than $250,000. Yet you are laughing, which is, even though the joke is on you, of Grant Cardone and the team because they bought trademarks and domain names to continue to build a moat around the product to keep others from being able to get into the space. So let's finish up the video. But you got to understand, man, the joke is on you, Gary. And it seems like Gary's a good guy and really wants to help people. But from an IP perspective, he doesn't understand it, and he found out real quick. So let's finish up this
one. And it had, look at that. See any similarity between that logo and this logo? That's Cardone Ventures.
Are you serious?
That's Cardone Ventures.
Are you joking or are you serious?
I wish I was joking. They just started this. Yeah. So Brandon Dawson went out while I was his business partner in March of 2024, while we were still business partners, while Sage and I were running our podcast and feeding leads to 10X Health and boosting 10X Health. Brandon,
and let me know in the comment section if somebody is your business partner and they own 18% of the company. Do you have to run everything by them before you go out and buy companies, before you go out, get trademarks, things of that sort? If somebody owns 18% of the company, I own 82%, there's no way that I'm kind of running every decision by you. I may let you know what I'm doing, but I'm not getting authorization or approval from you. You don't own majority of the company. Again, this guy seems like he a good guy, but
Dawson went out
doesn't understand the business
and bought a trademark from a doctor, trademark called Ultimate Human Analysis.
Absolutely, Brandon.
Never even told us. We found out he bought the trademark a few months later, and he goes, "Oh, I bought this trademark to protect you guys." And we're like, "Well, why would you buy an Ultimate Human trademark? I've got the Ultimate Human podcast." He goes, "Yeah, I brought it to
look at you. He has the Ultimate Human podcast. He's asking him, why would you buy the trademark? Dude, you don't even own a trademark to your Ultimate Human podcast. This is what I'm saying. You guys have to wake up from this IP standpoint. Because if you did own a trademark to the intellectual property to the Ultimate Human podcast, Grant Cardone, they would have paid you a lot more than $250,000 for the company because they would have had to buy the company as well as the trademark. Again, you're talking about why would you guys buy the trademark to the Ultimate Human? And I have the podcast, which you just have the podcast called The Ultimate Human. You don't have any trademark. You don't have any domain name. So again, when you get in bed with a big dog, such as Grant Cardone and a team, they're going to get you together real quick and you're going to kind of, I'm not going to say what I said, but let's finish this up and move on to the next one.
Protect you guys. So he went out and bought this trademark, sat on it. I sued him on the 26th of December. On the 28th of December, he went out and bought, in the name of that trademark, he bought the social media domains, Ultimate Human Analysis. Then on January 4th, a few weeks into our lawsuit, he bought ultimatehuman.com. And now he's starting Ultimate Human Community, the Ultimate Human. Look at the font. Look at the coloring. Look at the letters. The brand has been so tarnished that the Grant and Brandon just dropped the 10X brand like a stone. And now they're chasing the, obviously the Ultimate Human brand.
Man, that's enough of that. Look it. Obviously, that's crazy to say that a brand has been tarnished. Clearly, Grant Cardone and the team is still using the 10X, but that's crazy to say that, hey, this brand is tarnished, even though that brand has took your business from making $10,000 or $20,000 a month. All of a sudden, it's doing $17 million a month. You're saying that the brand is tarnished? It seems like they were playing chess and you were playing checkers. They're getting the intellectual property, the domain names, the trademarks. You're sitting around like, dude, why are you guys doing all this? Yeah, I don't know, man. I agree with you. I agree with you, Brandon. Gary is tripping. But again, this is the whole point of this channel. This is the whole point of what I'm trying to do and trying to instill information to you guys. I'm not sure if you remember, but back a while ago, Big B Coffee, the co-founder Mike McFaul, is not as big as Starbucks, but Big B Coffee, which started here in Michigan, is still doing $200 million a year in revenue. And Mike McFaul, when he was on the show, he talked about how he has two companies. He has the company that sells the coffee, then he has a company that owns the IP. And the company that owns the IP licenses the licenses to the company that sells the coffee, the IP. In exchange, the operating company gives the company that owns the IP 10% of the revenue. So, for example, if the company that's selling the coffee makes $200 million, which is what they're doing, they're paying $20 million a year to the company that owns the IP, which gives that company more credibility, or gives the intellectual property more, just kind of credibility and value. And again, I can guarantee you, if this guy Gary was doing a similar thing where he has the Ultimate Human podcast, but he has another company that owns the IP, and kind of he was giving money to the IP company to kind of give credibility to the value of the IP, Grant Cardone would have probably paid him $500,000 for the actual for the actual company as well as the intellectual property, but he didn't do that. Instead, he just sold the company 82% of the company for $250,000, and he's kind of wondering Hey, man, why are these guys getting more IP and getting more businesses and all that? Domain names, so forth and so on. Dude, that's the whole point of business. You have to get assets. And intellectual property is an asset. You got to build your moat around the product so that people are not being able to kind of steal the product, take the product, or sell the product. And seems like that what Grant Cardone and the team was doing. I actually like Grant Cardone, so maybe I'm biased in this way, but it seems like this guy, it's just kind of not business savvy. It seems like he really wants to help people with his genetic testing, with his nutrient supplements, with the podcasts that he's doing. But as it relates to business, acquiring assets, that being intellectual property, acquiring other companies to kind of help your company, seems like this guy doesn't have it. So I would love to know your guys' thoughts on this. Seems like Brandon, hey, it seems like he's maybe on my side with this one as far as this guy's tripping, maybe doesn't know what he's talking about. But I would love to hear you guys' thoughts on this one. In the meantime, we're going to move on to Trader Joe's. I'm not sure if there's anybody in the chat who shops at Trader Joe's, but man, they got a mean Joe peach tea. I love Trader Joe's peach tea. And it seems like Trader Joe's was maybe kind of doing some foul stuff, at least according to the court. I'm not going to go through the article. I already have done a maybe 10, 15-minute video on this article. Go check it out. But it seems like you have two different entities here. You have Trader Joe's, the company, then you have the employees. And it seems like the employees were trying to unionize. I'm pretty sure you guys heard of, what is it, UAW, the union for the automotive union. It seems like, Tesla and Elon Musk, they've been trying to keep Tesla employees from unionizing for a while, and they seem like they've been successful, at least up until this point in time. I'm not sure why Trader Joe's, who sell groceries and things like that, the employees feel like they need to unionize, but it seems like they were in the process of unionizing, and Trader Joe's essentially slapped them with a trademark infringement lawsuit, which I actually don't blame. If you go check out the full video that I did on this, this is kind of more so of a recap, but the employees were selling pens and buttons and coffee mugs using the term Trader Joe's, which again, if I have the trademark, if I own as a company, if I own a trademark Trader Joe's and you are using a trademark to kind of make money without my permission, you're committing trademark infringement. Trader Joe's slapped them with a lawsuit. And an interesting twist, the district court, and I think this was out in Cali, if I'm not mistaken, the district court not only dismissed the lawsuit, but they also made Trader Joe's, the company, pay Trader Joe's, the union, $112,000 for attorney fees, which I thought that was outrageous. And they pretty much, the district court, the judge at the district court pretty much said, hey, you're trying to weaponize the legal system against your employees because they want to unionize. That may be true, but if you're committed trademark infringement, it's trademark infringement. Just because I may be weaponizing the legal system against these people so that they can stop union, yeah, maybe that's maybe an outcome of it. But if somebody's selling your product, selling things based off your trademark name on it, that's trademark infringement, and they have a cause of action. So I was actually really surprised that the district court actually said that Trader Joe's, the company, were trying to weaponize the legal system against the employees and therefore dismissed their action, as well as made them pay $112,000 to the attorney for the attorney fees of the union. Seems like Trader Joe's, the company, appealed it to the Ninth Circuit, which is again a circuit out in California. So we'll see what happens with that one. But again, this was at least in my opinion, this was surprising. You can see here, I have it on the left-hand side, the icon. Now that tote bag to the left is Trader Joe's tote bag, and the tote bag to the right is Trader Joe's United, which is the union company or the employees that are kind of trying to form a union. That's the tote bag that they were selling. Now, mind you, as I said before, Trader Joe's has a trademark on the term Trader Joe's. So if you're selling items with the name Trader Joe's on it, that's trademark infringement, or at least I got a cause of action for trademark infringement. Whether or not it also kind of prevents them from being able to kind of unionize, that's really irrelevant in my opinion. You're still committing trademark infringement. So again, very surprised that the district court had this ruling, but it seems like Trader Joe's, the company, has appealed it to the Ninth Circuit, which acts as a court of appeals, or the appeal court for the district court in these intellectual property matters. So we have to kind of keep our eye out on things and see what they talk about. So again, I'd love to hear you guys' thoughts on the Trader Joe's. Let me know whether or not you shop at Trader Joe's. I haven't shopped at Trader Joe's. There's one around the corner from me, actually. I haven't shopped at Trader Joe's in a while, but back when I was in a prior relationship in my past life, man, they used to give me this, and you got a ton of calories in that peach tea, that Joe's peach tea. That joint was slapping. I think they sell that peach tea at other stores. It wasn't just Trader Joe's, but they got theirs from Trader Joe's. So let's kind of move on to the lawsuit of the week, which is, I kind of threw you guys off with this one. Watermelon Glow. And actually, I'm going to pull it up here. It seems like this is in a beauty space, cosmetology, beauty. It seems like, and I'm just so we understand who we're talking about here. This is let's see, a Glow Recipe. I'm not sure if anybody has been a Glow Recipe, but it seems like they have a nice thing going. So Glow Recipe, they sell a number of different beauty products, cosmetic products. Seem like lip balm here, maybe some toner. Just kind of going through their website here. And even if you go to their IG, I'm not sure if the IG will pop up. Let me see. Yeah, the IG is not popping up on the screen that I'm sharing it. But they have a nice, 2 million followers on IG. So this company is they're kind of doing some big things here. And as we kind of go to the lawsuit, see if I can pull up the lawsuit. Is this the right lawsuit? There we go. Is it? Yep, this is it. Let me make this kind of a little bigger. There we go. So Glow Recipe is suing Makeup by Mario. And I'm not going to pull up Makeup by Mario, but they seem like there's some big dogs too. I think Makeup by Mario actually has about 20 million or 14 or 20 million followers on Instagram. So this is actually a pretty big case here that's going on. And I'm not sure if anybody has shopped at either Glow Recipe or Makeup by Mario. Clearly, this cosmetology, things of that sort. And this is up in New York. So this is on the East Coast. This lawsuit is in the East Coast, Southern District of New York. We're going to go through it quickly. As you can tell, it's only 13 pages. So we're going to be able to get through this one very quickly. And I would love to hear you guys' thoughts in the comment section. Let's go. Nature of action. This is an action by Glow Recipe to prevent and restrain Makeup by Mario, willful trademark infringement of Glow Recipe's distinctive watermelon glow trademark. So this whole thing is over the trademark watermelon glow. I got some watermelon that I just got from the store yesterday. So watermelon glow apparently is the trademark that Glow Recipe is suing Makeup by Mario for infringing. Glow Recipe brings this action for trademark infringement under Section 32(1) of the Lanham Act for unfair competition. I'm going to read that. I'm going to skip the jurisdiction and venue. Let's get to the good stuff. Glow Recipe is a renowned cosmetic and skincare brand trusted for its clinically effective, fruit-forward, and clean products. Seems like that's one of the big things from what I was looking at the website. They have a lot of fruit-type products, products that are made by fruit. The company was founded as a small startup in 2014 with a vision towards sharing beauty, innovations, and trends from Korea to customers around the world. So now I'm interested on whether or not this is a Korean company or not. For anybody in the chat who knows of what is the company name again? Glow Recipe. Is this a Korean company or it's an American company? Let me know that to the extent that you have that knowledge in the chat. Korea to customers around the world. One of Glow Recipe's top-rated products is a watermelon glow sleeping mask product. Prior to its launch, the founders tested over 1,000 formulations to perfect this innovation product before introducing it to consumers. Once it hit the market, the product sold out numerous times with thousands of people lined up on a wait list. That's crazy. And again, they don't go off into it, but if they have some type of formulation, mind you, and I'm all about kind of protecting all the intellectual property, whether it's a copyright, trademark, patent, or a trade secret. If they kind of tested that many formulations that came out on one that is kind of selling a ton around the world, if that were them, I would definitely make sure that formulation is protected via a trade secret. So even though we're talking about the trademark in this case for watermelon glow, it seems like they may also have some trade secrets for the formulation as well for the sleeping mask. Since that launch, the watermelon glow range of products and expanded and has remained enormously popular. They receive regular press mentions as a best product in Glamour, Allure Magazine, HuffPost, Bustle, Refinery 29, among others. Indeed, in August of 2024, WWD included Glow Recipe in its watermelon glow products. And man, that's crazy. It seems like watermelon glow is and again, this kind of goes to show you, always talk about when you file for a trademark on a term, you have to file for the particular class that you want to protect it in. So in this case, they have watermelon glow. Well, let's go one by one. They have watermelon glow protected in cosmetics, which is class 3. Watermelon Glow, that's protecting the cosmetics, non-medicated skincare. You also have the sleeping mask, Watermelon Glow sleeping mask that they have protected in cosmetics, so forth and so on. So they have a ton of trademarks that's based around this Watermelon Glow, which again goes to show you that it's extremely popular. That's why they have so many trademarks for it. That's crazy. Let's see how many trademarks. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. So they have 14 trademarks that's surrounded around this Watermelon Glow. Again, let me know in the chat if you guys have tried this Watermelon Glow, whether it's it seems like the sleeping mask is one of the things that hits home. Since its founding, Glow Recipe has expended a substantial amount of time, energy, and resources promoting and marketing the Watermelon Glow marks so that consumers would instantly recognize the Watermelon Glow marks. They spent over 56 million? Hold on. This company has been around for 10 years and have spent 56 million in marketing and advertising efforts to promote its brand and products. How much money do you think this company is making or has made in 10 years if they spent $56 million in marketing and advertising? That's crazy. Look, when I go through these lawsuits, I skim them. I don't kind of read it in detail. I just skim them just to make sure it's all sweet. And I definitely didn't realize that they spent $56 million in marketing. That's crazy. Glow Recipes products, including those in connection with the Watermelon Glow marks, are sold on his website and with various, so they're in retail. Sephora, I know I've kind of been with some girls in Sephora. Mecca, I've never been in Mecca and caught beauty. You guys have to let me know if you guys have come across this Watermelon Glow. This sounded a little bit like Fenty. As a result, the Watermelon Glow marks are widely recognized both by the consumer public and the trade. Man, look, if you spend $56 million on advertisement, then I would imagine that it's safe to say that people know you around the world. The Watermelon Glow marks signify the high quality of Glow's recipes, cosmetic, and skincare products. It embodies significant distinction, reputation, and goodwill, all of which belong to exclusively to Glow Recipe. Okay, let's get to the good stuff. The finished wrongdoing. Makeup by Mario. In or about 2024, so this is just last year, well after Glow Recipe has acquired exclusive rights in his Watermelon Glow marks, Makeup by Mario began selling lip serum as Watermelon Glow. Again, that's and you guys have to obviously keep in mind that this is a lawsuit that the plaintiff attorneys drafted. So what Glow Recipe attorneys drafted, so it's going to be it's going to be favorable to them. But just kind of based on 17, sometimes I'll be ready to wrap it up. Like, what? You're selling lip serum that has Watermelon Glow? Obviously, that's trademark infringement right there. But let's keep going. Watermelon Glow, as used on the finished goods, is identical in whole or in part to the Watermelon Glow marks owned by the Glow Recipe. I mean, I should have pulled up the website to see if they still selling it. A lot of times when they filed a lawsuit, in this case, Makeup by Mario would take all that the alleged infringement products down. But I'm not going to go through it now. Because the infringement mark is identical in whole or in part to Watermelon Glow marks, it is confusingly similar. Okay, that makes sense. The finished goods are directly adjacent or identical. Again, that they are both selling makeup, lip balms, things of that sort. I would imagine that it's safe to say that it's similar. Upon information of belief, Makeup by Mario distributes, markets, advertises, promotes, and sells its cosmetic products to the same customers. Okay, that makes sense. Makeup by Mario use of the infringement mark threatens Glow Recipe's business presently conducted under his Watermelon Glow marks, as well as Glow's Recipe ability to explain into logical, foreseeable areas beyond Glow's Recipe consumers and services. And this is why I kind of was getting frustrated with your boy Gary, because he doesn't know the game. Again, going to maybe a couple stories ago where he's saying, hey, he's telling Grant Cardone and his team, hey, why are you guys kind of buying these domain names and buying these trademarks? Because he doesn't understand. When your product becomes popular and successful because it's selling a lot, other people are going to try to knock it off. And Grant Cardone and the team, they're master level business guys, so they're going to build their moat around the product. That being with the domain names as well as the trademarks. So again, this is this is right along the lines of why you would get trademarks, so that when people knock off your product, you have a cause of action against them, whether it's trademark infringement, trade secret infringement, patent infringement, so forth and so on. So like I said, it was totally weird, and I apologize for going off on a tangent or going back to that Gary what's the name, but this is the exact reason why you get trademarks. This is the exact reason why you get intellectual property. So when somebody starts selling your product, because everybody wants to be successful, but let me tell you as an attorney who's been doing this for 10 years, Once you become successful, other people are going to start to sell your or steal your product and start selling it. And if you don't have any intellectual property or any way to sue them, then you're SOL. You're shit out of luck, and people are going to take market share away from you. So that's why, Gary, you actually get trademarks to get your IP protected. Defendant's use of or make up by Mario use of the mark. Now let me get back to the lawsuit here to finish up. Mark threatens Glow Recipes business presently conducted. Okay, I already read that. Make up by Mario acts are causing and unless restricted will continue to cause irreparable harm to Glow Recipe and to its valuable reputation and goodwill. Okay, hey, that sounds about good to me. And we're going. I mean, again, it's trademark infringement. Just going through the different causes of action. So that's pretty much it, man. That's let me know what you guys think about kind of the lawsuit. Let me know if you guys have tried the watermelon, whether it's the mask or it seems like they got some lip serum out there. Clearly, if they spent $56 million in revenue or in advertising over the last 10 years, this thing is selling like crazy. And I'm not sure if it seemed like it maybe started out of Korea. Yeah, let me know in the chat if you guys have kind of ran into this watermelon glow or the watermelon lip balm. It seems like it's very popular. Again, to the extent that you guys have some intellectual property or you guys want to get off into intellectual property, I had a couple different client meetings, prospective client meetings this past week. And the first thing that I always tell people, hey, man, whether you have a product, whether you have a service, make sure you protect it via the intellectual property, whether it's a patent or a trademark, copyrights, or it's a trade secret. Because once you start selling this thing, and to the extent that everybody want to be successful, to the extent that your stuff you start moving units, just the name of the game, people are going to start trying to knock you off. And if you don't have your IP situated, your IP protected, then like I said, you're SOL. So whether you're an aspiring entrepreneur or you are our entrepreneur, make sure you're protecting your intellectual property. So, and hopefully you guys got something out of that. This was a good one, man. We kind of covered a lot. Let me know what you guys' thoughts in the comment section as we kind of wrap up here. Please hit the like button for the YouTube algorithm, as well as hit the subscribe button to be a part of the IP community. I actually have also some member-only videos where I'm filing in real time copyrights, as well as kind of doing some pretty testy conversations that I'm having. I'll be kind of uploading a trademark of me filing my own trademark here live so that you guys can kind of see what that encompasses. We have some cool things coming out. We have an ebook coming out. We have a digital product, getting your ideal to market. So we have that digital product coming out. We also have some physical books coming out that it's really for kids, but adults can get something out of it. It's going to be my first copyright is the first one. Then we're going to go from there. So there's a ton of things going on the channel that you guys can get down with. So again, please hit the like button for the YouTube algorithm, as well as hit the subscribe button to be a part of the IP community. Again, it's a great Sunday. Daylight saving times is ended or here, whatever the case may be. It's getting darker later. I'm thinking I may go get a cigar here. My alma mater, as you can tell, my jersey in the background, Michigan State, has won a Big Ten championship in basketball. So I'm trying to think, do I drive to Indianapolis for the Big Ten tournament this upcoming weekend? So there's a lot of things to kind of think about and kind of go through. I will be here again next Sunday with kind of new stories to share with you guys, new lawsuits to break down. And again, hopefully you guys enjoyed this one. Until next time, you guys take care.